Good evening and welcome to Arizona Horizon. I'm Ted Simons. The tsunami of high-profile sexual harassment allegations continues unabated. Joining us now to help define sexual harassment and talk about why these incidents seem to be increasing is Gordon Lewis. He's a partner in the employment practice section of Jones, Skelton, and Hockley. Welcome to Arizona Horizon. Good to have you.
Thank you very much. Thanks for having me.
All right, let's get a definition here to start things off. Sexual harassment is what?
Well, under the law, sexual harassment is unwelcome conduct of a sexual nature, either comments or conduct or jokes or other behaviors of a sexual nature in the workplace where one of two things are present. Either the conduct is sort of a condition of the employment, or there's some employment decision that's going to be based on your acceptance or rejection of the conduct. Rub my leg and I'll give you a promotion, or rub my leg and or I'll put you in the office in the basement. Those types of things would be considered sexual harassment. What used to be called sort of quid pro quo kinds of activities. Right. And sexual harassment is also unwelcome conduct of a sexual nature, where it is so severe and pervasive that a reasonable person would feel like it has altered the terms and conditions of their employment and caused them to work in a hostile work environment.
So, unwelcome sexual advances.
Yes.
Requests for sexual favors.
Yes.
Obviously that one.
Certainly.
And the idea of verbal and physical harassment of a sexual nature. I mean, even the verbal thing, this counts as well.
Oh, absolutely. Now, you have to have conduct under the law in order to be actionable. It would need to be severe or pervasive. So either one really significant event or several events that are less severe. But any comments of a sexual nature, your jokes, your innuendos, your asking people out, that can be considered harassment if it's committed amongst co-employees.
Has the firm definition and even just the general definition of sexual harassment, has that changed over time?
It really hasn't changed in quite some time. That's the standard that has been established for sexual harassment in the workplace for quite a number of years.
So what's going on here? Why are so many people coming out and saying so-and-so did such and such? And we're talking 5, 10, 20 years ago.
I think that it may be that the conduct hasn't changed, but there's been a change in the acceptance of the conduct, or the willingness to speak out about the conduct that is happening in the workplace. It seems like that type of behavior in the workplace has existed for a number of years. But in the environment that we're in currently, I think that more people are comfortable saying that this happened to them, and asking for either redress or just bringing attention to the fact that this is a problem in the workplace.
I've seen some reports that 70% of women do not report harassment. Are they not reporting harassment because there still is confusion out there? I don't know if what he did was harassment and I don't want to don't want to rock the boat here, or is it just simply, I don't want to rock the boat here?
I don't know what might cause somebody to feel uncomfortable in reporting to their employer. Hopefully every employer makes clear to their employees that behavior of that nature is not acceptable, and they make it clear how they can report, how they can be sort of protected or have that type of behavior corrected so that their workplaces are a more acceptable professional environment.
And you're talking about the workplace. What happens if the workplace, as in this most recent incident with Charlie Rose, his production company, some of the workers were working out of his house, out of their homes, not necessarily at the office? Office is one thing. Home environments, are they same rules apply, exact same rules?
Well, if you are a worker and you're in a place that you're expected to be as a result of your work, you're on a business trip, you're at a meeting, you're at a social function that you would be expected to be at, and you're subject to inappropriate sexual behavior in that environment, that can be actionable, regardless if it's in your cubicle or at the Christmas party at the hotel down the street. I mean, the Christmas party is the most perilous event that most employers have to face.
Yeah, and for a variety of reasons.
Absolutely.
Okay, so we hear now criticisms like, oh, I can't tell someone that they look nice anymore. I can't put my hand on anyone's shoulder anymore. You do have to watch that, don't you?
Well, I mean, in order for harassment to be actionable, I mean, it has to be something that a reasonable person would find offensive. But you want to make sure that you're taking stock of the circumstance if you're going to make a comment to an employee, if you're going if you're going to touch an employee. In a lot of circumstances, you do that at your peril, and you want to be very careful. Just to make sure that your comments or conduct in the workplace can't be misinterpreted or isn't unprofessional. So if you're telling somebody they look great every single day, that is actionable. That would be problematic.
And especially if you're doing it, and after the first couple of times, the other person says, I get it. You don't need to keep saying that. I'm a little uncomfortable with that, and you keep doing it. Then, obviously,
obviously, you're engaging in behavior that is obviously unwelcome, and that is coming along to being severe and pervasive and potentially actionable. And if an employee is subject to that kind of behavior, hopefully they're able to go to their human resource department or some other reporting agency to take some steps to make sure that it's corrected.
How difficult to prove harassment in court?
I think that the standard for actionable harassment under Title VII can be fairly high, but oftentimes if you get to court in these cases, then it's very bad news for the employer.
Because things should have been settled beforehand.
Well, there are stages before where it can be resolved, and oftentimes employers don't want to be in the position of going to court with those types of cases. Sometimes you have to, but it's a circumstance you don't want to be in, so hopefully employers are taking steps to prevent it at the outset.
And we should mention, this is a form of sex discrimination under the Civil Rights Act.
Yes, absolutely.
This is serious business here when it gets to that level.
Yes, indeed. It's a violation of Title VII of the Civil Rights Act of 1964.
And it's not, again, it's people of the same gender. It could be people. You don't have to be in a position of authority, do you? I mean, that's not necessary.
No. I mean, if the employer had reason to know of harassing conduct amongst coworkers, then the employer can be liable for that conduct. So the employers should be taking steps to examine their workplaces and make sure they have a work environment that's professional and appropriate.
And the bottom line, and you've mentioned this a couple of times, the bottom line is, if a reasonable person were to hear about this, and they would say, there's really not harassment going on, or they would say, that's not right, that's pretty much where the court would draw the line.
It certainly can be. It can vary from circumstance. But really, for employees, if you think that there's some reason that your conduct could be interpreted as harassing or problematic, then you should do something different. And if you're an employee and you're subject to that type of conduct, hopefully you feel comfortable in reporting it so that it can get corrected at the outset, rather than having it pervade for a long time.
Do you think this is the kind of thing where the situation's going to get worse before it gets better? Are we just going to get an avalanche or a tsunami of these things before things finally calm down and people finally figure out what they can and can't do?
Well, I certainly hope that people are getting a sense of what you can and can't do in the workplace and what would be appropriate conduct in the workplace. That your workplace should be professional and not a place for a lot of innuendos or jokes or things that would make people uncomfortable. I'm not sure how many more people might say that this type of conduct happened to me in the workplace. But as it's becoming more known in public, it very well may be that more people come and say that, yes, this happened to me too.
Attorney Gordon Lewis, good to have you here. Thank you so much for joining us.
Thanks for having me.